now on the Southern Arizona News Network, Cox Cable Channel 3.
In our Legal on 4 segment, what you need to know about the standard real estate contract. There are so many things to consider. In fact, did you know after signing a contract for a house, it is nearly impossible for the buyer to sue the seller? Our legal expert, Craig Wisnam, explaining why this has something to do with that disclosure statement.
Yes, when you sell a home, one of the requirements in your typical contract is to fill out this disclosure statement, which says, basically answers a lot of questions about the property and points out anything that you know that might be wrong with it.
What are some of the errors that maybe you've seen people make?
Well, you just want to err on the side of disclosing. I know it kind of goes against your nature when you're trying to tell something to let people know there's a problem, but for your protection, you want to just let them know anything you can think of up front.
But how picky should you be?
Well, if it's anything that, people might come back later with a serious problem, you probably want them to let it know about it. If it involves something with a roof, serious issues like that, if it's something that's not going to be more than $10 no matter what it is, then you probably aren't going to lose a lot of sleep over that.
And of course, you can use this disclosure statement to your advantage too and point out brand new things that you've put into the home and things like that as well, right?
Exactly. There's no reason, but basically when you talk about not being able to sue the seller, it's because the buyer, after they've had a chance to inspect the property, more or less takes the property as is.
Let's talk about that inspection period.
Okay.
That's the chance for the buyer to opt out?
To opt out or to find things that they want the seller to fix.
Okay.
So it's a chance, basically, it's normally 10 days under most of those contracts unless the sellers or buyers write something different in, and it gives them a chance to say, to get a home inspector there to check everything out to make sure there aren't any major problems and to ask the seller to fix some of the minor things.
Can you change the sale price at that point?
The buyer and seller could always agree to do it if they want. If the buyer basically says, I think there's a big problem and I'm going to walk unless you lower the price, they could do that.
And what about who's paying for what? At what point do you need to make sure that that's all clearly written down and decided?
That's pretty much right off the bat in the contract. Now, the contract has a lot of places where there's defaults about who will pay for what. But you can change those, and even if you don't change those, both the buyer and the seller have to understand where these things are going to be paid from, because you don't want a surprise when it's time for the closing. And
what are these things we're talking about?
Realtors' commissions is the big one. Title insurance, which is both to protect the property and if there's a lender involved to protect the lender's interest. The escrow fees to cover the title works paperwork and the documents and things like that. Real estate taxes that get prorated.
Right. Well, what happens if one side doesn't follow through? You have the contract and then one side drops the ball.
Basically, the contract itself will have various remedies for what happens if one person doesn't follow through. Normally, if the buyer doesn't follow through, it might be the earnest money gets taken. If the seller doesn't follow through, they can normally force the seller to sell it. And there can be other damages as well.
Get it in writing.
Get it in writing, have it clear. Understand what you're signing.
All right, Craig, thanks so much as always. And if you are one of the many